Clem versus Tomlinson. All right, Mr. Bowdich.
May it please the court. My name is John Bowdich, and I represent the appellant, Stephen Andy Clem. Starting directly with bankruptcy policy on adversaries, the discharge exceptions here, 523A2A, are to be narrowly construed in favor of the debtor, since the aim of the bankruptcy code is to give the debtor a fresh start. I want to start with that background that it's supposed to be strictly construed. Of course, Fifth Circuit law, Recover Edge versus Pentecost, 523A2A claims contemplate frauds involving moral turpitude or intentional wrong. Fraud, if that is just implied in law, without any imputation of bad faith or immorality, is insufficient. And I think that's really important in this case because it's not the typical builder adversary case that you see. This wasn't a one-man custom builder who was in charge of accounting and construction and all the issues. It was a large company with 2 construction divisions in 2 different areas of the state, building hundreds of custom luxury homes just on a fixed fee contract. Unfortunately, that business model just failed by doing it as fixed fee contracts. And so you don't have this where, Andy Clem wasn't someone who was personally involved in the construction issues. He was just the president of the company, although he did have considerable interaction with the Tomlinsons in the sales process. This wasn't a case where he derived some personal benefit or some monetary benefit as a result of any of the actions that are complained of. And it isn't even a case where there's a proven allegation that money from the Tomlinsons was used on another job.
Well, get to the issues.
Sure. Well, and I did think that backdrop was important. There's 2 primary reasons why this court should reverse and render. The limitation bar and then collateral estoppel. On the limitations bar, so that's Rule of Bankruptcy Procedure 4007C. Again, this is something that's supposed to be strictly construed. And that's ample Fifth Circuit law on that. Claims objecting to discharge must be filed within 60 days following the initiation of the 341.
You're talking about the court's grant of modification of the claim halfway through trial. Is that what you're talking about here?
It wasn't halfway through trial. It was after the conclusion of trial, which was certainly important. So imagine it here, right, where on all the claims pled, Andy Clem won. It was only after he won on those claims that the bankruptcy court went into chambers for roughly an hour, came out and said, okay, Tomlinsons, you didn't win on the claims you pled. And that one I even wanted to quote. The bankruptcy said, a couple of issues and theories had evolved over the course of the trial and or had developed in the evidence that had not specifically been articulated in the live complaint or other pretrial pleadings. Right? So everything that we actually tried, closed evidence, everything else, Andy Clem won on. It was only afterward that the bankruptcy court said, well, I think you really tried these other claims. The problem being that those other claims were the claims that were initiated and tried in the arbitration. So you can see what happened here, right? So the Tomlinsons.
Let me ask you, did you or your opponent, were you the lawyers in the arbitration?
The Tomlinsons' lawyers were the same. My firm was not. It was a completely different firm.
You're a bankruptcy firm?
No, construction litigator, just associated with Martin Thomas, who is a bankruptcy lawyer.
Okay.
And so that's what happened here, right?
Court find that, in fact, your client waived this issue?
And that couldn't be further from the truth,
Well,
right?
didn't the district court make that finding?
It did. It's just absolutely wrong. We filed a motion to dismiss. So it was part of our answer. It was part of our trial brief, right? It was part of our motion to dismiss. I think what may have thrown Judge Lindsay and the district court off is when citing to that, we cited to the wrong motion. We cited to the motion for reconsideration and not the motion to dismiss. The motion to dismiss was actually filed prior to the motion for reconsideration.
But the amended complaint does satisfy 15C.
I'm sorry, what?
15C is satisfied in all for the amended complaint. So,
And I would absolutely disagree with that
okay,
because
well, if as a legal matter it's satisfactory and both the district court and the bankruptcy court determined that, then why isn't that what?
the district court didn't determine that. They relied on waiver to try to avoid the issue, right? And so what the bankruptcy court did, and of course the bankruptcy court was going to have to, they're the ones who, the judge that after we tried the case decided to change what it was, right? Because you got to really see it. I know the Tomlinsons argue that it's just an amplification of the original claim, but that's really not the case at all. And if you look at, and we did it in Appendix B, right? So if you look at the false misrepresentations that are in what is the first amended objection to discharge, the live pleading when we started the trial, those are all pre-contractual representations, all things that were said to induce the Tomlinsons into signing the contract, right? And then so if you then look at the live pleading after trial and after the court sua sponte decided that different claims were changed, I mean, even in that amended complaint, they started off with saying they list the same pre-contractual representations and then say, subsequently, the debtor used false concealments and concealed material facts to fraudulently induce plaintiffs into staying into the contract.
What case law did the bankruptcy cite for mid-contract fraud? Fraud in the course of contractual performance. That's the gravamen of the amendment, isn't it?
It is, and then you switched it from being just a misrepresentation case to a fraudulent.
Well, that's what I'm asking you. What Texas case supports that theory? In other words, they contracted to use concrete piers, and the owner had to approve a substitution, so they put in helical piers without the owner's approval. And how does that transform from breach of contract into fraud?
And I would have said it was just breach of contract.
Well, I know you would, but where's the case law that says that can be fraud at all in Texas?
And I would say that it doesn't really exist. I don't think the bankruptcy.
Well, we'll plow that ground later.
Sure.
That's just a serious question I've had.
And if you look at the damages, that would support exactly what you're saying.
What about the insurance?
Because they're economic damages as opposed to reliance damages. I'm sorry.
I'm sorry. I thought you were finished, but if you're finished, Judge Jones's question first.
Yes, Your Honor.
Are you done?
Yes, Your Honor.
What about the insurance fraud that couldn't have been known about until it was revealed during the first day of trial? That the concealment of the insurance that would have been very important at the arbitration and all these other places too.
Okay, so I'm glad you brought that up. A few really good points. So first is the bankruptcy court complained to me, why wasn't the insurance policy disclosed in the Rule 26 disclosures, right?
So that's the CGL policy, right?
Correct.
There's a question of builder's risk, which was required in the contract, and CGL, and they never bought, let me just get the facts.
Mm-hmm.
They never bought builder's risk, and they had CGL, but they didn't reveal it, right?
Yeah, and let me explain that a little further and go into a little depth, right? So obviously my firm didn't handle the arbitration. I don't know why the CGL was not disclosed in the arbitration. I just know that my client didn't have anything to do with it, right? I mean, that's just something that the lawyers did. And so when the 341 meeting happened, which was prior to this adversary being filed, the trustee asked him if there's insurance, a CGL policy, and Mr. Clem identified the CGL policy at that time. The Tomlinsons and their counsel were at that 341 meeting. So there wasn't any concealment of this insurance policy. That just wasn't the case.
Well,
And
the judge stopped the trial, so there was the perception of the judge and the opposing counsel in their brief that there was a concealment of the thing, and because you don't normally just stop the trial and say we're going to continue it till this is looked into.
And so that's where I was going on the Rule 26 disclosures. So this claim is a fraud claim against an individual. So of course I put in the disclosures, the Rule 26 disclosures, that there's no insurance for that there's no CGL policy that covers an individual's fraud. And that's the claims in the adversary. When the insurance policy, the CGL, was disclosed to the trustee, at that point, that's the trustee's claim even, right? That's Bella Vita's, not Andy Clem's insurance, that's Bella Vita's CGL policy that was disclosed at the 341 meeting, and at that point, the trustee could pursue any claim on that insurance policy that he wanted to, and in fact, that did happen. It didn't result in any coverage, right?
Was that because it was untimely?
I wasn't involved in that, but
Well, is there anything in the record about it?
I don't think so, Judge. But
If you're in the construction business, is this I'm just asking a question because I do not know the answer, and you have builder's risk. Does the CGL normally exclude a builder's risk?
So two different things, right? So first, just to tell you about builder's risk, that's something that you purchase once the construction goes vertical. I mean, theft, damage by like hail or storm or anything else, right? And so that's like a good analogy is a car policy, right? You order the car, you're not going to get insurance then. You're going to get that builder's risk insurance when the car is delivered, right? As soon as the house goes over. But the CGL policy, no, in my construction law experience, I would tell you that the builder's CGL policy wasn't going to cover this. Perhaps the subcontractor who punctured the water line, his insurance potentially, right? But even that would have been an uphill battle.
The error, that's right. I understand that.
Right. And so this was a huge red herring that I think the bankruptcy court, while the bankruptcy court may know bankruptcy law very, very well, did not have a handle on how insurance works whatsoever. And I think the court really did obviously think it was a big issue, just like Justice Elrod said,
She didn't really attach any damages to that anyway.
Correct. Sort of to jump back into then the limitation bar, it really is two different claims for two different time periods, right? And what was particularly interesting about the limitations problem is the Tomlinsons then, in trying to get around their relation back problem, right? Because this certainly isn't an amplification. It's brand new claims. Even Jernigan said it. The claims that you tried, Andy Clem went on, but I think these other claims that were not pled were, right? So to get around that problem, they said, well, you knew about these claims because of the arbitration, right? Of course, that's not the test. You've got to be on notice based on just the live pleading, right? It can't be something you learn in discovery. It can't be because of some prior arbitration proceeding. It has to be noticed from the pleading. And if you look at that pleading, fraudulent concealment or failure to disclose, not mentioned once, right? And there's a reason why. They had to avoid those allegations because that was going to plead them right into collateral estoppel, right? Which is then they would be retrying the arbitration, and in the arbitration they did not win on fraud, right? And so I'm going to sort of fly into the...
Can we talk about that? Whether
Which part? Now so in the collateral estoppel, they're dead to rights on collateral estoppel.
Because if they didn't have a reason to go fully into it,
So if you look at the arbitration award and you look at its findings, everything that they,
They're not actual findings, that's a problem too, the arbitration award.
well, the findings I'm talking about, which would be paragraphs 3, 4, I think it's 5, 3, 4, 6, 14, and 15, there's a specific factual finding on each one of the items that they eventually went on in the second, in the new issues.
Should they have gone full bore into that because the things that were part of the complaint hadn't yet come to light?
They had come to light.
But they had not yet come to fruition. They argue that they didn't know that they needed to go full into it, and especially they didn't know the issue.
Oh, that couldn't be farther from the truth.
I'm just saying, that's.
Yeah, no, yeah, and it's just a bad argument, because if you look at what the arbitration panel actually ruled on, they said there was concealment of the waterline puncture, there was concealment of the change to the helical piers, right, and that there was a failure to disclose the accounting issues, right? Everything that they want, and those factual findings on that in the arbitration panel, right? And then the arbitration panel said, but it didn't amount to fraud, right? It was not done knowingly.
Wouldn't your client still be on the hook for the economic damages, though, because of the Texas law under the DTPA?
Not in a 523A2A action, no. But just based on the arbitration award, yes, he was jointly and severally liable. But as soon as they've got to try to convert that from a DTPA economic damages award to a fraud finding, this, where they need some immorality or intentional bad faith, right? That's what the arbitration panel specifically said didn't exist.
Well, there's not a direct personal benefit requirement under the bankruptcy code.
Yeah, and it's okay if I continue. I know I'm right.
Go ahead.
Yeah, okay. That kind of bleeds into another issue, right, as to you're getting into the evidence as to whether or not he had any personal involvement, whether or not the Tomlinson's briefing on, if he made those personal representations, right, that he could be personally liable, even if it was just the company who got the money. So I agree with what you're saying. That's just not really what the facts were, right? I mean, it was Bella Vita who made these representations, right, in the contract. They couldn't rely on the representations of Mr. Clem. This is why they lost on the issues they actually did try, right? Because of the entireties clause.
I appreciate it. I'm sorry.
Yeah. No, okay. Thank you.
Okay, you have time for rebuttal. Mr. Powell?
Good morning, and may it please the court. I'm Beau Powell, here on behalf of the appellees LaDanian Tomlinson and LaTorsha Tomlinson.
How long did you arbitrate this case?
So that's one point I wanted to bring up, Judge Jones, is that my firm arbitrated the case, but I was not a part of the firm.
I don't care. How long did it take?
A couple of days, Judge.
And a panel of 3 arbitrators.
Yes.
And your firm identified about 12 different issues.
Lots of claims were pled, yes.
And you won on breaches of contract, and you lost on fraud, and you lost on DTPA, right?
I think that.
I think because you'd gotten triple damages on DTPA, so.
Well, no, we won on DTPA, but what the arbitrators found is that there was not a knowing violation of DTPA,
Okay.
which allowed them to sidestep the triple damage.
Okay, but anyway, it was a significant evidentiary hearing, right?
Evidently not significant enough to lead to any detailed findings.
Well, your client and his wife probably went on the stand, didn't they?
Yes,
And I assume Mr. Clem went on the stand?
I'm sure.
Okay.
So I guess I'll just jump right to the question Judge Elrod asked Mr. Bowdich, and that is, why would we go after a fraud claim in an arbitration when we have a DTPA claim pled? The DTPA is a more consumer-friendly statute. It has a less onerous elements you got to prove. You don't have to prove intent. You don't have to prove reliance. You got to prove the consumer was able to sue the defendant under the DTPA, and the DTPA provides like 30-something reasons defendant can be liable thereunder. So it's a lot easier to win that claim, and more importantly, the DTPA allows for a recovery of attorney's fees in addition to the damages recovered. So while a fraud claim does not. So you got two considerations there. It's an easier claim to win, and I can win attorney's fees.
Well, your clients pled fraud.
They did, yes.
And what, if any, differences are there between DTPA, what the arbitrator found, and what Judge Jernigan found?
Sorry.
Go ahead.
Judge Jernigan quite simply found a continuous pattern of concealment of the facts and the nature of the project that continued through trial, quite frankly.
And what is your best case for the fraud during the performance of a contract?
Absolutely. And so,
I didn't see a citation anywhere. That's why I'm asking you.
and when Your Honor asked that question, I just thought in my head, I don't remember one either. But what Judge Jernigan did was go through a painstakingly detailed process of how ordinarily a breach of contract is not fraud. We all know that. I agree. But when you look to post-contractual conduct, you can find instances that prove there was never any intent to comply with the contract all along. So that was one facet. But then Judge Jernigan...
He didn't find that.
She did not, but she went on to find that, again, this pattern of concealment, things are arising in the scope of this project that created a duty to provide more information to the Tomlinsons. And rather than providing that information, they flat out concealed it.
Well, the case boils down to four different things. Number one, insurance. But we'll get to his argument that CGL could in no way have covered Mr. Clem's individual liability. So one, insurance. Number two, helical piers versus concrete piers. Number three, puncturing the water line. And you call that fraud. Well, they didn't tell him about it, but they found out within 24 hours. That's negligence or malfeasance or something, but it ain't hard to construe that as fraud. And number four, fooling around with the 10% down payment, right? And and there was back and forth constantly with regard to that 10% down payment between Mrs. Tomlinson and Clem or his people, right?
True.
So where's the fraud? Where's the intentional? She says, Jernigan says it's fraud by omission. Where was the duty to disclose?
I'm sorry, I wasn't trying to...
Go ahead, I'm just saying.
The duty to disclose arose, number one, with the peers, when the supposed unavailable...
That's what the contract provided for, right? The contract said you have to put in concrete piers and you have to tell the owner if you're going to change, right?
True.
So breach of contract is not fraud.
Well, because Judge Jernigan looked at first the conflicting testimony, which she found unbelievable, that, oh, we told them and the Tomlinsons approved the piers and along those lines. Then she looked at the documentary evidence where emails and texts, I think emails only, are being sent to the Tomlinsons telling them, hey, we're putting in the piers, the pier work is happening, it's progressing, all while knowing they had made this switch to these other piers without notice, without approval.
But how does that, what case law transforms a plain and direct breach of contract into something fraudulent? And I mean, cite me a DTPA, since she ends up saying this is DTPA, but the arbitrators didn't specifically find it.
Well, I think it fits squarely within a fraudulent inducement or fraud by non-disclosure.
Well, it's clearly not fraudulent inducement because there's no pre-contractual fraud here.
The inducement was inducing them to stay in the contract when they...
Well, where's a case that says inducing someone to stay in a I mean, they didn't put down any more money than that. There was there was the 400,000, and then there was a subsequent draw of about 125, right?
There was a third draw too. It was about
Oh,
207,000 paid in addition to the deposit.
So why is it, if that amounts to a case of fraudulent, it's what we used to call, when I was a bankruptcy judge, the theory of fraudulent stringing along. But there was, I don't recall a case that said that stringing along was actionable as opposed to breach of contract. So this is where I'm coming from on this.
I understand, Judge, and I don't right now have a specific case I can point the court to, but the fraud by non-disclosure, certainly what's going on in this case fits squarely within those elements. And most importantly was Judge Jernigan's findings that this case, or this house, mattered very much to this young man who was just getting off the ground, and he was going to do anything he could not to lose.
I understand the pathos of this situation. Certainly I do. But I am very troubled when we are going down the road of changing contract breaches into tort, because the Texas Supreme Court has been pretty clear about trying to limit that or control it within identifiable parameters. And here, if this had been a case of fraudulently stringing them along to be in the contract longer than they should have been, then it seems to me the damages would have had something to do with the extra draws. But instead, the damages are exactly parallel to breach of contract.
I disagree, Judge. The first part of damages awarded by Judge Jernigan did coincide with the breach contract damage, the destruction of the lot, the removal of the unauthorized piers. But the second element of damages that Judge Jernigan awarded were the stringing along damages, and namely the two additional draws amounting to $207,000.
The reason I said they were parallel is that it's the same amount as the arbitrators awarded, less the attorney's fees.
Not on the draw damages.
$640,000 in each case, if I'm not mistaken.
The numbers wound up lining up, but when the court looks at the arbitration award, the only draw damages, I'll call them, the arbitrators looked at and they said, well, I think there was an overcharge of, I think it was $26,000 or $29,000. And Judge Jernigan looked and said, but for this fraud, the Tomlinsons would not have made the last two draw payments, and that was $207,000. So we got 9 times the damage that the arbitration panel awarded.
Well, then I made an arithmetic mistake, but what is the, which I will check out, what's the ultimate damages awarded by Judge Jernigan?
I'm not sure I understand the question.
What is the amount of damages, the dollar amount?
It was around $640,000, so I don't remember the specific. But you're right, the two did coincide quite close, which was a funny coincidence, I suppose.
I'd say it's more than a coincidence.
Well, so with the lot damages, it was not a coincidence, because that was our offer of proof to the court is, we've got this debt from this construction problem from the arbitration award. Here's what we proved in the arbitration it was going to cost to repair the damage caused by the flooding, what it was going to cost to remove the unauthorized piers, and so on. And there was no contradictory evidence whatsoever. So Judge Jernigan, that was all that the court had to rule on. So that's not a coincidence. But again, the fraud damages from the other draw payments was not addressed in the arbitration award.
Please repeat you several minutes back, you were discussing what you claimed were the fraudulent statements or misrepresentations to the Tomlinsons. Repeat the one about the piers that you claim was fraudulent, about we're installing the piers.
Yeah, so there was, and I think it's cited in a footnote in Judge Jernigan's opinion, but certainly it's in there. There was some emails. So let me back up. The Tomlinsons say, we never knew about this switch to piers. In our mind, things are going along on the project well. we go to a charity golf tournament, and our neighbor, Jason Witten, walks up and says, "What's going on at your house? You dang near flooded my home the other day." Bless you. And that was the first time we go, "What's going on here? What are you talking about? What flood?" Start looking into it, then we find out early August that these piers had been switched, and during the installation of the unauthorized piers, a lot was damaged. Well, what Judge Jernigan then looked at was,
No, you told us that there was a misrepresentation made assuring them that they were installing the correct piers. That's what I want to hear again.
yes, sir, yes, sir. And so at trial, Mr. Clem said, "Well, me and my people, we told the Tomlinsons about these unauthorized piers being used." That was denied. But then what Judge Jernigan looked at was, given the testimony, went back to the documentary evidence. And what we saw was by July 20th, there was already a bid being received for the steel helical piers. By the end of July, they're writing the Tomlinson saying, "We're putting in the piers, things are going along at the project, we're moving along great," all while never mentioning ever that we didn't use the product we knew was important to you, we were required to use, and we were required to notify you when we weren't using the product. So they're creating a false impression in the Tomlinson's mind that the correct concrete piers are being used under the home, while knowing they're not using those, while knowing they were required to notify us, and while knowing they were required to get authorization from us. They just went ahead and stuck them in there. While they're sticking them in, they hit the water line and caused $200,000 worth of damage at the home. So it was the creation of the false impression that the right product was being used, the project was moving along, all while behind the scenes working on a switch. Does that answer your question, Judge Barksdale?
Assuming arguendo that the claims are barred by, some of the claims are barred by collateral estoppel, what is left?
If I understand the argument correctly, I think nothing.
Nothing's left?
I think so, Judge.
Well, you know, I mean, I say I'm very sorry about this, but they're a general unsecured creditor.
That's true.
And that's the problem for general unsecured creditors when a company goes bankrupt, absent carefully defined exceptions to discharge.
Well, and I think that's why Judge Jernigan's opinion was so important, and that's because the Grogan v. Garner tells us that bankruptcy protection is for the honest but unfortunate debtor. And again,
I've seen a lot more dishonest ones, believe me.
I'm sure you have, Judge, and you know.
It's the last refuge of scoundrels, to be sure.
But as we all have already heard, the dishonesty, it started from before the contract was signed.
But there's no finding of that.
And it continued through the trial.
But what about as to Mr. Clem's individual liability?
Absolutely. So that is not an element to be proven with the 520. I'm sorry.
Would that be something still left? His individual liability, which is supposed to, yes, wouldn't that be, they'd still be on the hook for that?
If collateral.
On the economic damages?
Is that the question? If collateral estoppel?
Yes.
I don't think so, because he was found individually liable in the arbitration. So if collateral estoppel applies, then that wipes out the individual liability.
Because he wasn't found?
He was.
He
Excuse
was.
me. He was found individually liable in the arbitration. So if collateral estoppel applies, then we're hosed, I guess, if I understand the question correctly.
May I ask you a question about the CGL policy?
I'm not a coverage lawyer, but I'll do my best to answer it.
Well, obviously, I didn't know all the details here, but Mr. Bowdich is saying that this is a red herring because the CGL policy was owned by the company, and the liability here is allegedly attributable to Mr. Clem individually, and he's not getting discharged. And wouldn't there ordinarily be a fraud or intentional tort exception in a CGL policy?
Yes, that's true. But the important thing was, and this is what Judge Jernigan went through, is that, so we get our arbitration award, $744,000. If we knew there was insurance, then you start trying to collect on the insurance policy. You don't go chasing debtors through bankruptcy court hoping to get pennies on the dollar as a general unsecured creditor. But we didn't know about the policy because they affirmatively stated there were no policies in the arbitration.
But does comprehensive general liability cover contract violations?
Generally, no.
Yeah.
But, I mean, you can recast it as a negligence claim and hopefully get a settlement or, things like that. So really, I just want to be clear on collateral estoppel real quickly. This court's made clear you got to have specific subordinate factual findings required for the bankruptcy court to look at to be able to determine that identical issues to the question of discharge were decided in the arbitration. Here we've got a 4-page arbitration opinion and quite frankly nothing much else in the way of a record. So there was no subordinate factual findings, and more importantly, like I already discussed, the DTPA claim was an easier claim to prove. Why focus on the fraud claim if you can win easier and get fees? It's only when we're faced with the new defense of bankruptcy did we.
May I ask you, as an officer of the court, is it fair to say that in the arbitration your client pursued that theory, that we will pursue DTPA and not necessarily fraud on the theory we can win that?
Judge, I don't really know because I wasn't there, but what I will say is that when we put on these kind of construction claims, the evidence is the evidence. And, the fraud claim you're getting into, you got to have circumstantial evidence to prove intent, which is obviously hard to come by. You can't get in the defendant's mindset. So I would bet that the evidence was just really the construction claim.
Okay.
And the fraud claim is just pled as an alternative.
Okay. Thank you. I mean, you've got a little more time if you.
I just want to talk real quickly about relation back and 15C. And I've got the appellant's proposed sufficient record excerpts, and I'm looking at Appendix Tab K. And the citation there to the record is Record 366 for the first amended complaint and Record 1790 to 1791 on the second amended complaint that's alleged to be time-barred. And if we look at Record 366, subsets D, F, and G, those are the exact same factual scenarios that were brought up in the second amended complaint. And so it absolutely was an amplification of the original issue, not only original to the adversary proceeding, but going all the way back to the arbitration proceeding. And I'm not using that to say that's where the relation back comes, but they knew it was an issue in the arbitration. They knew it was an issue in the first amended complaint, and the specific species of fraud was just clarified in the second amended complaint, but arose from the exact same facts pled. So I see that's my time, unless there's any more questions for me.
Thank you very much.
Thank you.
Mr. Powell, just off the record, not off the record, but off the clock, you used an expression in answer to Judge Elrod that, quote, "we're hosed," close quote. I would drop that from, it's not funny. I would drop that from any comment in a court, in a pleading, or in an oral argument. I'm amazed you would say that in this court.
Well, Judge Barksdale, I absolutely apologize. I didn't mean to be vulgar or crude or anything like that.
Word to the wise.
Absolutely understood, Your Honor.
All right, rebuttal, Mr. Bowdich.
Thank you, and may it please the court again. First thing I wanted to hit was there were some comments about whether or not the fraud claim was actually litigated. That bar or standard, if you will, for the Fifth Circuit is really low. I just wanted to read a couple of cites. It's the Fifth Circuit will deem an issue to have been actually litigated if the prior court conducted a hearing at which the parties appeared and gave evidence, which I think may have been exactly what Judge Jones was getting at. That's from Responti, which is 397 F 3rd at 272. Citing another one, the requirement that an issue be actually litigated for collateral estoppel purposes simply requires that the issue is raised, contested by the parties, submitted for determination by the court, and determined, which certainly happened here. It's just a low bar. Whether or not they focused on the DTPA claim over the fraud claim really has zero bearing. I did want to jump quickly to...
Ray King and this requirement for specific subordinate factual findings on the identical dischargeability issue in question.
So for that one, Judge Elrod...
Since you brought this up.
Yeah, so if you're looking at the arbitration award, and that's what I'm looking at right now, and if you look at some of the findings in it, and it's under the heading findings, right? It talks about in number 3, the subsurface water, right, which caused the helical piers, which, for Andy Clem, he was just trying to do the right thing, by the way, right? So the engineer tells him, hey, you're not going to be able to do these concrete piers. You're going to have to use something else. I recommend helical piers. And so even though it's going to cost a lot more, and that's what they did, right? They followed the engineer's recommendation.
Really argue that he's just trying to do the right thing when the judge
Is it a violation? I agree. Is it a violation of the contract? Is it a breach of the contract? Absolutely. You can't run from that, right? That just is what it is. It was a breach of the contract because they did not get it in writing from the Tomlinsons to approve it. As far as the factual findings go, just to answer that question, Justice Elrod, in those factual findings, it's all about the fraudulent concealment in the arbitration, that they concealed the water main puncture, again, for at least 1 day, and that they concealed the helical piers. Interestingly, Ms. Tomlinson's testimony on helical piers is, she was at the property and saw all these, if you've never seen them, there's just imagine these metal pilings. Well, they're all stuck up in the air before they're drilled down to bedrock. They're all still, she found out mid-process, right? It didn't stop it, didn't say why this, why that, right? They let that process actually complete, and then the reason that the real gravamen was that Judge Jernigan never allowed us to develop and show, they moved the house 40 feet. The whole reason they wanted to scrap this and get rid of this builder is because that same Jason Whitten complained about the house being right up against the road. So they moved it back 40 feet. Judge Jernigan wouldn't let us bring in the as-built survey or anything else to show that.
You mean before they broke the water line?
No.
This was aesthetic or what?
Yeah, to move the house back, yes.
All right, and what did that have to do with anything?
That's the real reason they terminated the contract and hired another builder. What I would say is it wasn't because they used helical piers that were as good a product as
Or flooded out the foundation?
Right, but I do want to jump into your, construction problems happened, right? Again, that's something you can't run from. Was there a breach of contract? Absolutely. Did the water main break? Absolutely, right? It's just how you deal with it. And so on your question on the damages, they do line up. These are contract damages, right? So just as you heard, all the helical piers and the piercing of the water line, that all happened in July of 2015. Those 2 draw payments making up the $207,000, June 1st and June, I think it was either 16th or 26th. Both of those were paid prior to these problems. The only problem that existed when those 2 payments were made was the accounting issue. And you can't even say that was concealment because they're giving them the accounting reports that showed the $448,000 had not been exhausted. They knew it hadn't been exhausted. That's why they were complaining. But they still made the 2 payments anyway, right? Once they knew of the problem and still made the payments, that you can't have damages resulting from that. So there are 0 reliance damages because they had already paid the $207,000. They had already paid the initial deposit of $448,000, which is directly now in, I think, what Judge Jones was seizing on, which is these are contract damages.
All right.
I see I'm out of time.
That's all you need to say.
Okay.
The court will stand in recess for 10 minutes.
Thank you.
Thank you, gentlemen.